Hello, hello, hello. Hello, hello, hello. Hello, hello, hello. Hello, hello. Hello, hello, hello. Hello, hello. Hello, hello. Hello, hello. Hello.
Ladies and gentlemen, distinguished guests, members of the faculty and fellow students, on behalf of the Board of Advocates, I welcome you to the 22nd Annual J. Reuben Clark Law School Moot Court Final Competition. I'm Heather Cagle, Chair of the Moot Court Board of Advocates. This afternoon's competition is a culmination of a process that began last semester to select next year's National Moot Court team. The 6 students competing today have demonstrated excellence in their written and oral advocacy skills and will represent the law school and Brigham Young University at next year's National Moot Court competition. The competitors will be introduced to you by Jeannie Campbell, one of the co-directors of the National Moot Court team. Today's competition will be judged by a panel of distinguished judges. Judge J. Michael Ludig of the United States Court of Appeals for the Fourth Circuit will act as Chief Justice. The other members of the panel include Judge Michael Murphy of the United States Court of Appeals for the 10th Circuit, Judge Lloyd D. George of the United States District Court for the District of Nevada, and Judge Ronald M. Holdaway of the United States Veteran Court of Appeals. The teams today are competing for 3 awards. These are Best Brief, Best Oralist, and Best Overall Team. Immediately following the oral arguments, the judges will deliberate and then render their decision. Before I turn the time over to Jeannie, there are just a few housekeeping matters I've been asked to discuss. First, please remember that for purposes of this competition, this room is now a courtroom. Please remain seated throughout the arguments and try to remain as quiet as possible. Second, following the presentation of the awards, the judges have offered to remain here and to answer any questions that you might have. And the last thing, before I turn the time over to Jeannie, is all of the first years need to sign the roll, and I believe it will be circulating throughout the argument. So, again, try to pass it quietly and make sure you do sign your name. Thank you very much. And Jeannie?
I'll probably talk loud enough. I don't think I really need this microphone. But as Heather said, I'm Jeannie Campbell, and Richard Flint and I are the directors of the national team. And I wanted to take a minute to introduce the participants of today's demonstration. Since I did this last year, it was kind of a personal thing for me, and I enjoyed the experience quite a bit, and I'm hoping that all of the participants today will enjoy it as well as I did. Arguing for the petitioners, on this side, I'd like you all to stand. We have Thomas Isaacson, Elizabeth Crofts Mitchie, and the primary brief writer is Robert Carlson. And on the respondent side, we have Mike Lee, Bradley Roylance, and the primary brief writer is Trinian Paulson. Thank you. I just wanted to say a few words to the participants. You've all worked really hard, and I've seen most of you practice, and you're all really good, and I think you should feel privileged and proud that you're here today, and you're all winners just for being here. I know it's easier to say that because I'm not sitting there, so I don't have to worry about it. But I think you should all feel very good for being here. I know you've prepared very long and hard, and I commend you on that. And I thank all of you for being here. First year students, I know you have to be here, but I can promise you it'll be a good experience for you and you'll enjoy it. And we'd like to welcome all the family members and friends and especially the judges for being here with us today. Thank you.
All rise. Oyez, oyez, oyez. All persons having business before this, the Honorable, the Supreme Court of the United States, give your attention, for the court is now sitting. God bless the United States and this honorable court.
Be seated, please. Court's ready to hear argument number 80-18. Whenever you're ready, counsel.
Mr. Chief Justice, and may it please the court, my name is Thomas Isaacson, co-counsel for Petitioner Galler-Honduras. Let me introduce co-counsel Elizabeth Crofts-Mitchie and Robert Carlson, our primary brief writer.
Glad to have you.
The first issue before the court today is whether a federal court should suppress evidence that was gathered in violation of state law. The reason that federal courts should suppress such wiretapping evidence are two. First, the federal wiretapping statute, Title III, mandates that evidence gathered in violation of state law should be suppressed in federal court. And number two, if this court admits such evidence, it will resurrect the silver platter doctrine and encourage forum shopping. To my first reason, there are two sections of Title III that we need to discuss today. The first is the authorization section. In the federal statute, there are two portions of the authorization section, one dealing with federal courts and one dealing with state courts. The one we need to focus on is the section dealing with state courts. The federal statute states that a state judge may grant, in conformity with federal procedures contained in Section 2518 and in conformity with the applicable state statute, an order authorizing a wiretap. What does this language mean? This language means that in the federal statute, when a state court authorizes a wiretap, that the federal law demands that all of the laws dealing with the validity of that wiretap and the execution of the wiretap should be given deference by the federal courts. What this means is that once the state machinery has begun to roll, after an investigating officer receives a wiretapping authorization, then the state laws that governs how he is to carry out that wiretap should govern, and if those laws are violated, then the federal courts should conclude that the wiretap was gathered unlawfully and should suppress the evidence.
Counsel, as I read Section 2516-2, it's concerned exclusively with the authorization order itself and not at all, at least arguably from the language, with the execution of the wiretap. How do you get around that as a statutory construction matter?
You're correct in that section only deals with the authorization process, and therefore we need to do what this court did in United States v. Sotomayor and look at all of Title III. The other section that we need to look at with the authorization section is in 2518.10. This is the suppression section. This is the section that states any aggrieved party may move to suppress evidence that was gathered either one, unlawfully, or two, gathered not in conformity with the order of authorization.
But if Section 2516-2 is limited, as the language suggests, to the authorization order, then the 2518.10 section that you're referencing would be likewise limited.
That's right. And so if the authorization order requires the investigating officer to follow state law, then he would, and if he does not follow state law, then the evidence would be gathered illegally. And so the language in conformity with the order of authorization is what this court needs to construe.
But notice 2516-2 didn't say that the interception shall be in conformity with 2518 in state law. It says that the authorizing order shall be in conformity with those two provisions.
That's correct, and that's how some courts, for example, United States v. McNulty in the 10th Circuit, have construed the dealing with whether an authorization order is valid. Now, in United States v. Sotomayor, they construed not only the authorization order process, but how the wiretap was carried out. Because when they read in footnote 13 of United States v. Sotomayor, they said, when we read 2518, together with the language in the federal statute that says if it's gathered unlawfully, or if the wiretap was not gathered in conformity with the order of authorization, that includes two laws: the law that deals with how a wiretap authorization should be given, and the execution of the wiretapping order.
That's what they said in footnote 13, but frankly, I couldn't find any textual analysis in that footnote 13. It seemed to me to be nothing but ipsy-dixit. Did you find any kind of statutory hook for the statement in footnote 13?
Yes, they did. They cited those statutes that we've just been discussing.
Well, I realize that. They cited the two statutes generally.
That's
but
right.
They didn't parse them in a way that was satisfactory to anyone who's attempting to read the statute.
That's right. They did not parse them in that way, but they simply read the various sections of 25 of the federal statute, and they tried to look at them as a whole and how they work together. Now, the way the interaction is between the federal law and the state law is this. The federal law sets out the statutory minimums when dealing with wiretapping law that the states must follow. In other words, if a state decides to make a wiretapping law and decide how it will govern this intrusion into people's privacy rights, then they must make their law at least as strict as the federal statute.
But in response to the Chief Justice question, Sotomayor really doesn't hold, as you suggest, does it? Isn't it just for purposes, or mustn't we look at it for purposes of providing guidance to this court? But Sotomayor doesn't really hold in your favor. As I remember, they actually authorized and upheld the wiretap in Sotomayor.
That is correct. They did admit the evidence. And there's an important distinction in Sotomayor that will help assist this court. In Sotomayor, they looked at what type of state law was violated. The law that was violated in Sotomayor was a New York law that required that a sealing of the evidence be done. In other words, there was a 30-day wiretap authorized, and New York law required that at the conclusion of that 30 days, that the evidence be sealed. It's to protect the evidence for trial, and it's to also not allow tampering of the evidence. Now, what Sotomayor said is if there was a law, a state law, that was based upon granting the individuals of that state more privacy rights, if a law was based upon that premise, then we would give deference to such law.
That's what they said, but from our point of view, isn't it just as reasonable to suppose that the sealing was for purposes of protecting privacy rather than just being for evidentiary or procedural purposes?
I would agree, and I would hope this court would do that. I would hope that this court would conclude that any law that was violated should be given deference to by the federal courts.
So you think that Sotomayor and your case are the same, in effect?
In essence, yes, we do.
But where, I mean, I understand the distinction between the privacy and the procedural that the Second Circuit adopted, but I just find no support for it in the statute. Is there any support for that particular distinction in the statute? And I take it that there's none, is there?
There's no support for that distinction in the language of the statute. And again, what they did is they construed the statute to mean that Congress intended for the states, when they invoke a desire to grant their citizens more privacy rights and legislate laws in that area, that they would give a deference to those laws. And therefore, they did make that distinction without necessarily any statutory support.
Well, we interpret laws, don't we? Not just abstract thinking that we surmise Congress engaged in. So I can't do that, can I, under the statute?
Well, I believe that the statutory language can give this court enough support.
Where's that?
Well, again, it's the statutory language that in the federal law that says evidence can be suppressed if it's gathered unlawfully. I read that language to mean exactly what it says. And the way the scheme is set up in Title III is that Congress intended...
That proves too much. If that's true, then there's no such distinction between the privacy, substantive privacy law and the procedural, is there? If it violated a procedural aspect of state law, it would be suppressed, wouldn't it?
I agree.
So it wouldn't, that wouldn't be the Sotomayor holding. It would be something vastly in excess of that, wouldn't it?
That is correct. That is
Well,
correct.
you concede that the interception was lawful.
The interception was not done lawfully. No, we did not concede that. There were two laws that were violated. First of all...
At the time the interception was made, it was a lawful interception. It had been authorized by the state judge, and you don't argue the basis of that.
We don't argue the basis of the authorization. What we argue is that there are certain laws that were violated throughout the interception process.
It became unlawful nunc-pro-tunc, so to speak, by the failure to log it? Is that your contention?
Well, the laws that were violated in this case were two. Actually, there were three laws. First of all, Vulcan state law requires that a review of the tapes be done after each 24-hour period of interception. Furthermore, they require that a certificate...
But the interception's already taken place, the privacy's already been violated at that point, is that correct?
That would be true for the first period. But for example, if there was a 30-day interception period, and in the first day the privacy rights were unduly violated, what this law provides is that in the remaining 29 days, if there was not minimization done in that first day, this would ensure that in the remaining periods of interception, that the intrusion into the privacy rights of the individuals would be minimized.
So you could have a situation, I think this was a two-week,
This was a two-week interception.
So you could have a situation if they complied with the logging requirements where it was lawful one day and unlawful the next? Is that the sort of thing?
That's what the Vulcan state officials desired to do. They wanted to be sure that every day that minimization occurred and irrelevant conversations were not recorded. Now, one of the things that is required in the certificate of minimization is that they review the instructions given to the investigating officers. Therefore, they say, for example, if there was a situation where they were intercepting a husband and they found out after a few days that the husband was never home in the mornings and that the wife was home having personal conversations with her friends, these minimization reports would catch that. Therefore, in the remaining periods of interception, they would never turn the microphones on in the morning, and they would never gather those unnecessary private conversations that did not relate to the investigation.
But this is only relevant if we indulge this dichotomy of the Second Circuit, right? If we don't, then we've got to accept wholesale your argument that the statute forbids admission of evidence gathered in violation of state law, period, whether it's procedural or substantive.
Well, if this court desires to adopt the Sotomayor rule, that is fine. I believe that we come under the Sotomayor rule in as far as the law that was violated here would be given deference to, but this court does have supervisory authority over the administration of criminal justice in the federal courts, and it can tailor a law in any way it chooses. I would agree that maybe Sotomayor was held wrong, and if this court desires to incorporate all of that law, then it can do so. Now, the second reason that this court should press this evidence is that it would resurrect the silver platter doctrine that was condemned by this court in United States v. Elkins in 1960. Ever since 1914 in United States v. Weeks, when this court introduced the exclusionary rule, the silver platter doctrine was allowed. What this allowed was that state officers, in doing an investigation, if they did it without the help of federal officers, as in this case, if they gathered evidence illegally, then the federal courts would simply accept that evidence because what they concluded was that it was not a federal investigation. And because the federal officers didn't violate any law, the federal courts decided that they would allow this evidence in.
Well, what I couldn't understand about your argument, frankly, was that Elkins prohibits the use of the evidence if it was gathered in violation of the Fourth Amendment.
That's right.
Now, your argument is quite a stretch from Elkins. It is, I take it, that if it's a violation of some relatively insignificant state provision, then that too bars its admission. So this is not a case controlled by Elkins, is it?
Well, I believe that there's a distinction, but there's not a difference between this case and the United States v. Elkins.
Between a constitutional violation and an insignificant state law procedural requirement?
Well, I believe we can do that by labeling what type of Title III violation occurs. We could call a federal Title III violation one that violates the minimum statutory allowance in wiretap that we've talked about in the federal law before. That would be a federal violation, a Fourth Amendment violation, a constitutional violation. But in this case, we could also label a state Title III violation. What this would be is this exact case before us. In other words, the federal statute would incorporate certain state law as the federal law in cases like this when a state judge authorizes a wiretap.
Well, that can't possibly be the law because the Fourth Amendment would vary state to state.
Well, the Fourth Amendment would not vary state to state because all of the states have to have that statute or the statutory Fourth Amendment minimum requirement. Therefore, the only variation would be on top of that if there were stricter laws that a state desired to grant its citizens. And in the one case where state judges authorize a wiretapping order, then that law governing how that wiretap is to take place is incorporated.
No, but Vulcan says you have to have the review procedure, and now you're telling me under Elkins that means it's inadmissible unless you comply with that procedure. That is, in effect, to constitutionalize Vulcan's procedure. And we would do that under every state provision, presumably.
Well, we're not federally constituting that. What we would be doing is giving respect to the state constitutions.
You're arguing that the Vulcan State Code 802 is part of the Title III Omnibus Street Crimes Act. Is that what you're arguing?
It becomes part of it in this instance because the state authorized the wiretap. And that's right. That's exactly what I'm saying, is that is incorporated.
It's incorporated in.
It's
And
incorporated.
that's true of all 50 states.
It is true in all 50
Whatever
states.
cockamamie things they want to come up with.
They may come up with some.
Do you have any statutory history that you can refer us to for your position?
There is some legislative history, and specifically on Section 2516(2), the authorization section, that says that states may be allowed to make stricter rules in the authorization process than are granted in the federal statute. And so the legislative history does support the idea that Congress intended to give deference and to allow the states.
I take it doesn't go on and then saying those will be binding upon, and binding in federal courts.
It doesn't explicitly state that in the legislative history, no.
Does it explicitly state that in Title III?
Again, reading Title III as a whole, when it says that no evidence gathered unlawfully or not in conformity with the order of authorization can be admitted in federal court.
Isn't there legislative history to the contrary as well that could be read to take the opposite position?
None that I've seen. Your Honors, my time is up. This court must suppress this evidence or else the silver platter doctrine will be resurrected, and Title III does mandate that this evidence should be suppressed. Thank you.
Thank you very much, counsel. You may begin.
Thank you. Chief Justice, Your Honors, may it please the court. I'm Elizabeth Crofts-Mitchie. I'm co-counsel for petitioner Galron Duras. The second issue before the court today is whether the United States Court of Appeals for the 15th Circuit erred in holding that mandatory disclosure of a private political organization's membership list did not violate petitioner's right to associational privacy. It is our contention before this court that such disclosure did violate associational privacy rights of petitioner. It is appropriate for this court to reverse the decision of the lower court for two reasons. First, the government has failed to establish a compelling government interest in the Klingon membership list. And second, the government has failed to establish that demanding the membership list meets this court's requirement of the least restrictive means test. Now,
Is it not a compelling state interest to detect and prevent felonies, bombings in the United States? That seems to me to be the core of a compelling state interest, doesn't it?
yes, Your Honor, yet none of the things that the government points to establish a compelling state interest should rightfully have led them to Klingon. Let's first begin with their initial assertion that the 1991 incident that parallels the investigation into the Camp McCoy bombing led them to establish a compelling interest.
Well, I don't know if we're asking the right question. That's the question you may want us to ask, but is that the relevant question?
Well, I think it is. If you can't point to the evidence that led them to Klingon in the first place, then how could they have established a compelling interest in this organization's membership list? And based on the 1991 incident, they claimed that 3 of those responsible for that incident were Klingon members, and that gave them initial interest in the Klingon membership list. However, the record stipulates that they did not know this information until they had already begun the investigation in 1992, until Klingon had already been targeted, until their membership list had been demanded, and a deposition had been taken from the Klingon president. It was the Klingon president himself that told them that these 3 individuals had once been affiliated with Klingon, but were immediately expelled for their criminal activity.
But they knew it, did they not, at the time that the list was provided? And I take it that that's the point at which we're interested as to whether a compelling state interest existed.
Well, it is our position that they must establish a compelling state interest at the beginning, before they ask for a list. However, before they turned it over, it's true, Your Honor, they did know that those 3 individuals were associated with Klingon, yes. However, that simply reduces us to a guilt by association analogy, which would violate this court's principles in Uphouse v. Wyman.
Well, it's a little more than that, isn't it? We have 2 incidents that are strikingly similar.
Yes, Your Honor.
And when the second incident happens, certainly seemed, wouldn't it be reasonable to conclude that this organization might have members who are responsible? I mean, you're not asking, how many buildings do we have to have blown up before we say, hey, there's something here we ought to check into?
Well, Your Honor, it is our position that Klingon as an organization has never participated in any of this activity. And what you're essentially saying is that the activities of 3 individuals will rightfully bring an entire organization under suspicion. Now, it is our position
No,
that...
that's your interpretation. My interpretation is that there could well be some members of this organization, and it would be helpful to have that membership so we could, it might give us some clues or some help in obtaining that information.
And in addition, didn't the president of the organization make some very substantial, that could be called at least veiled threats that would invite some inquiry?
Your Honor, he made some statements that were very controversial on an ABC News correspondent, and that is the incident that the government attaches his second hope of establishing a compelling government interest. Now, of particular concern were the statements that there would be certain repercussions for the economic embargo and that demonstrations of disapproval were likely. So it basically comes down to our interpretation of repercussions and demonstrations. Now, one plausible interpretation is that there is trouble brewing and that they do intend to do something wrong. However, an equally as plausible interpretation is that they meant to do something peacefully. We simply don't know, and the record doesn't speak to this issue. And the record doesn't speak to this issue because when the government investigators took the deposition from the Klingon president, they never asked. They never asked of any of his intentions, and they never asked what he meant. Now, if we are willing to give this kind of political speech, political bantering, if you were, the credibility of establishing a compelling government interest such that it is able to prompt an investigation, not just into the speaker of those words, but into his entire organization, it is our contention that we will be giving the government a weapon against the First Amendment that it was really never entitled to have. And based on these facts, it is not able to establish a compelling government interest. However, if this court uses its prerogative and establishes that we in fact did have a compelling government interest, then there is one additional hurdle that the government must pass. And that hurdle was established by this court in Healy versus James, in which this court developed the least restrictive means available test. Under the core of that test, the government investigators do not have total dominion over those that they investigate. They must narrowly tailor their actions.
Well, now, I believe you said the least restrictive means. I don't recall that that's what we said in Healy at all, was it? We just said it had to be narrowly tailored, and there's a difference.
It has been interpreted by later courts as the least restrictive means. However, we're perfectly comfortable with the narrowly tailored language as well.
Didn't the judge do that in his order, limiting its use?
In the protective order, sir?
Yes.
The protective order will fail to help Klingon for one important reason. It was December 20th when the Klingon order was compelled to disclose the membership list, and that is when it in fact turned it over. However, it was March 3rd when the protective order was signed. That means this membership list was exposed for 2.5 months without protection. So from the Klingon perspective...
Exposed to whom?
Well, Your Honor, we can't be sure.
So you have no claim of injury during that interim period, do you?
Your Honor, we don't know that it went to anyone inappropriate, but you can see how the protective order fails to give them comfort after it was left unchecked for 2.5 months.
But you could come back to us at some point with that claim, couldn't you?
We could, Your Honor. Protective orders are adjusted all the time, and that is actually another reason that the protective order ceases to offer comfort, that protective orders can be changed and their scope manipulated by other courts. However, back to the...
So a protective order as a matter of law is insufficient?
No, sir.
Okay.
I was simply pointing out to Justice George's question that why the protective order ceases to give petitioner adequate comfort, as one would think that it would. However, back to the narrowly tailored investigation, we feel that this is a standard that the government simply cannot meet under our facts, because the first act of the government investigators was to demand the Klingon membership list. Now, as we know from this court's ruling in NAACP versus the state of Alabama, compelled disclosure of a membership list brings with it an automatic violation of associational privacy. Now, for the government investigators to have that be their first cause of action, we feel is inappropriate, especially when they had other options available to them, namely the Klingon president, Mr. Dukat. He had proven himself to be willing to help. He wrote them a letter on December 1st making two promises. First, that he would help in any way other than turning over the membership list, which he expressed that he felt would be a constitutional violation. And second, that he would answer any questions about a specific individual. If they could bring him a name, he would verify if they had any affiliation with Klingon. Now, it is clear from the record that they knew about Petitioner in time to bring his name to the Klingon president and verify his affiliation without the membership list.
So you're saying that had they asked him, he would have told them that the defendant's name was on the list?
Exactly. He would have told them if he had been a member or not.
So what's the harm in the case then if they'd have got the information? If you're conceding they'd have got the information anyway?
We're explaining that they could have gotten the information through a means that would have been narrowly tailored.
What's the prejudice to your client?
Your Honor, the prejudice is that the turning over of the membership list without his consent was an automatic violation
But
under
you're
this
saying
court's
that
NAACP
the
ruling.
order, the name would have been given to the prosecuting authorities anyway.
It would have been given, but it would have been given in a means that was not a violation. It would not have been a violation.
What's the prejudice as far as the prejudice to the case? I mean, there might be some off in the air, some bruised feelings or something, but we've got to have something that harmed the trial of the case, haven't we?
Well, Your Honor, we do, and we don't know that they would have gone about it in this manner as you suggest. However, it is our contention that it was a harm to the
It
case.
seems to me that once you've conceded that you would have no associational right to claim if the president had turned over the name in response to a request for that name, then you've got no associational claim at all that you can raise. The only thing that's left is the associational right of the other members on the list, as to which you would have no standing to complain.
Your Honor, that may be true, and yet that would give no weight to the narrowly tailored language in Healy.
Well, I'm not so sure that we're focusing on the proper point as to the narrow tailoring. Maybe that's why we were in a little bit of disagreement at the outset.
Are you suggesting that really these people are proxy for all of society, and this is to establish a standard for the future that's proper?
Yes, Your Honor. It is our contention that those membership lists should be valued and that the court properly ruled in NAACP versus the state of Alabama and in NAACP versus Button when it established that those membership lists really were valuable and there was a harm to be had when they were released.
So would you be happy with an opinion that said there was error, but it was not harmful to your client?
Well, Your Honor, if that error was substantial enough to suppress the membership list, yes, I would.
It would not be.
Well, then, no, I wouldn't. However, it is our contention, based on the fact that they knew of Petitioner, and we know they knew of Petitioner because on page 1-14 of the record, it specifically states that upon termination of the wiretapping evidence being collected by the state officials that Mr. Isaacson has already discussed with you, that those tapes were turned directly over to the United States Prosecutor's Office. Now, it was not until December 5th that they took the deposition from Mr. Dukat, the Klingon president, and it was not until December 20th that the membership list was actually turned over. So
Let me ask you this. If the membership list had been turned over to this court for review, would you not still have an associational right claim?
yes, we would.
And
If it had been turned over without consent, sir, yes.
So there's no distinction as between the executive branch and the judiciary in your mind.
No. It is a consensual disclosure in our minds.
So we can't even review it in camera to determine whether it should be turned over. That's extraordinary, isn't it?
It is a strict standard, and yet it is one that we feel that is of significant value to society, that it should be maintained when the information can be obtained in another way.
Are you aware of any case in history that has held that documents of any kind in a litigation could not be turned over to a court in camera?
For in camera? No, sir, I'm not.
I'm not either.
However, it is our position that petitioner was targeted simply because of his association with an unpopular political organization, and that began this investigation improperly. And based on this, it is our position that the membership list should be withheld and the 15th Circuit reversed. Thank you.
Thank you. We'll hear from the government whenever you're ready.
Mr. Chief Justice, and may it please the court, with respect to the wiretap issue, there is really only one question before this court, and that is whether the federal wiretap statute incorporates by its terms more stringent state standards governing the execution of a wiretap order. For two reasons, we urge this court to affirm the lower court's holding that no such incorporation exists. First, the federal wiretap statute and the clear language contained therein compels state judges to abide by state law in authorizing a wiretap order, but this incorporation extends no further. Second, even under the rationale used in the cases that defendant cites in explaining that this incorporation actually extends into the execution process, the defendant loses on this point for the simple reason that the only violations that the Vulcan police committed were procedural in nature and were not designed to protect the privacy rights of the individual.
Well, that sounds good, and you can say that it's clear, but frankly, I've studied this thing at great length, and I find the statute indecipherable. It's anything but clear to me. For instance, at 2518:10, when the cause of action is given, it says that any violation of any law will support suppression. Now, if that's clear language to me, and that's against your position.
That language is found in section 2518:10A1. And what it says is that any aggrieved person can move to suppress the evidence on grounds that it was, quote, unlawfully intercepted. And for two reasons, we argue that the defendant cannot avail himself of the protection of this section. First, the interception itself was not unlawful because the Vulcan police were acting under a validly authorized state court order for the wiretap. The interception itself was completely lawful.
Well, if the interception is ongoing and you violate the minimization review, then it seems to me that any subsequent wiretapping information has been gained illegally. That seems elementary. What would be the government's argument that that's not illegal?
The fact that the wiretap order itself was never withdrawn is an indication, first of all, that the interception was in fact valid and was not unlawful in any way. In addition, we do argue
they're not
that
going to be able to withdraw it unless these minimization reports are filed. Fair.
Could Your Honor restate the question?
Well, there's not going to be a withdrawal of the order earlier than the expiration date unless there is something that shows up in the minimization reports that are filed with the court.
That certainly is one possible argument. However, the wiretap authorization itself remained intact, and a police supervisor, someone within the department, or the judge himself, had he been given notification that these reviews were not taking place, could have terminated the order at any time. But it is our contention that the order did remain intact during the entire scope of the investigation. And furthermore, even if you do, wholly
There's a little bit
aside
of
from
sleight of
that,
hand here that I think I just picked up. This is only true if we accept your argument as to the scope of 2516-2, isn't it?
that is correct.
All right.
That is correct.
Okay, and if I don't, then you're stuck with the plain language of 2518:10, and you lose because it was a violation of state law, right?
Yes, but we nonetheless maintain that the interception itself was indeed lawful. And that brings us back to the point that you just mentioned, and that is that in section 2516-2, that's the section that gives permission for state judges to issue wiretap orders. It gives them permission, and then it gives them a mere requirement, or it gives this permission with a stipulation that they must authorize any and all wiretap orders in compliance with the applicable state authorization statute.
What's the purpose of 2516 if it's not to import state law into the federal cause of action?
It does incorporate state law into the federal cause of action, but as the clear language states, it only incorporates it into the authorization process. You notice that in the wording of 2516-2, the only restrictions apply to the judge herself in issuing the order and do not extend to any other party. And therefore, this incorporation of state law is by its nature and by its clear wording a provision dealing solely with the authorization
To
process.
sustain that argument, you've got to show that nothing in 2518 refers to anything other than the judge. And that you can't do, can you?
Certainly not. In fact, most of the scope of 2518 applies to the execution of the wiretap order.
As Sotomayor held, right?
Yes.
Okay, now if that's true, then 2516 can't be read the way you're saying.
And that's precisely why we disagree with the Sotomayor reasoning, because we believe that when you look at 2516, and in fact the rest of the provisions in Title III, it's clear that Congress, in adopting this statute, simply did not intend for any incorporation of state law to extend beyond the authorization process.
Well, then why was there the reference to executions of the wiretap in 2518 to which 2516 makes reference?
It simply states, in fact, that cuts in our favor, because it says that the state police, in executing the wiretap authorization, must abide by the execution requirements in 2518. And both parties have conceded from the beginning of this case that the Vulcan police abided by all federal standards in the execution of this wiretap. That brings us to our second
Well, they're
point.
certainly not contending that now. If I understand their contention now, they're contending that there was a violation of federal law because federal law incorporated the state law.
That's correct. And so I suppose you could say, if you look at our wording, our reading of the statute, which is the clear wording of the statute without any inferences, all that we see is an incorporation of state law authorization procedures, which does not exceed beyond the actual authorization process.
Well, then why in 2518 did Congress not say state or federal or both? Instead, it said violation of any law. Read as state or federal.
First of all, when we read that, it does say unlawfully intercepted, and that's why we get into that argument about how the interception itself was lawful. But in looking at the word lawful itself,
On its face, that encompasses state and federal law, doesn't it?
but for the fact that in all other portions of the federal statute, it appears to be referring to federal law. In one instance, and in one instance only, in all of the applicable portions of the federal statute, Congress went out of its way to mention state law.
That's the whole point. It didn't in 2518, so the negative inference is that it intended to include both state and federal law.
Your Honor, certainly that is one possible reading of the federal statute, but it is our position that when you read the federal statute, it appears obvious that in one instance, Congress intended to incorporate state law, and in another section, it did not.
So it's not quite as clear as you thought, is it? Basically, 2516 is fairly clear, but your problem is complicated by 2518-10, isn't it?
Yes, at least defendant would argue that it is complicated by 2518.
Well, it's more than just incorporating state law. It's incorporating state law for a particular purpose. Everybody concedes that state law is incorporated for the purpose of state court proceedings, I suppose. You'd have to say that.
Yes.
The question is it incorporated for purposes of federal proceedings? That's really the precise question.
That's correct. And that's why it's our position that with respect to the admissibility of evidence in regards to whether there was a violation of a post-authorization procedure required by state law, that the federal minimum standards will suffice in determining the admissibility of that evidence. And that leads us to our second point, and that is that even if you accept the rationale of the cases that defendant cites in support of his contention that this incorporation of state law exceeds beyond the authorization process, defendant still loses on this point because of the fact that the only provisions of state law that the Vulcan police violated were procedural in nature and were not designed to protect the privacy interest of the individual. When we look at the Vulcan statute, it becomes clear that there are some sections that are designed to protect the evidence itself and to preserve it for trial and to organize the evidence in such a way that it will be useful to the prosecutors.
Now, why do you think that the review procedure fits within that range of conduct? It seems to me that it's directed squarely at the protection of privacy. That is, every 24 hours you must review it to determine whether privacy has been unduly encroached upon. That doesn't sound procedural to me. That sounds substantive.
Yes, but there is another provision of the Vulcan state statute that deals precisely with what you're talking about. That is, the very next section in the Vulcan Code, in the Vulcan wiretap statute, says that the police shall conduct the wiretap investigation in such a way as to minimize the interception of phone calls not relevant to the investigation.
Well, that too is a substantive provision. It doesn't mean the first one's not.
Except that the first one merely deals with procedures designed to protect the evidence.
Well, I understand that you're saying that, and it is indeed a procedure, but in substance, it's designed to protect the privacy interest, unlike, for instance, the sealing requirement in Sotomayor.
Yes, but there are several things that the Vulcan statute requires the police supervisor to do in making the review. Every 48 hours, he has to review the tapes. He has to fill out a certificate of review. He has to summarize the contents of that tape and list any instructions that he gave to the officers as a result of the view.
That sounds procedural to me. The one that doesn't is the minimization requirement.
But that's exactly the government's point. That is, the minimization requirement itself is not contained in the scope of these provisions that the defendant has alleged that police violated. The minimization requirement itself is contained in Vulcan Code Section 802, subsection 3, and he has not alleged at any time, nor does he allege today, that they failed to minimize. And he hasn't even alleged that at any time his privacy rights were violated in any way. He therefore cannot avail himself of the benefit of the violation of these sections.
You're saying that, in a general sense, what the Chief Justice is saying may be accurate enough, but based upon this case, and that we should limit any ruling to the facts of this case, that there's no evidence to invite the inquiry that's being addressed. You may even agree that it's a privacy question, I suppose, but there has been no suggestion that there was any harm done as a consequence, and we need not address that. Is that partly of what you're saying?
Yes, that is correct. That is essentially what the defendant asked the court to do, is to dismiss this evidence on a mere technicality, not on the fact that the police failed to minimize the interception of calls not relevant to the investigation, not on the fact that his privacy was violated, but on the fact that for some unspecified period of time, the electronic content of this wiretap investigation sat on the plastic, or the acetone, if you will, of the physical tapes within the police department, and that they were not reviewed.
As Congress said is required.
As the Vulcan state legislature has required.
And through 2516 and 2518, the United States Congress.
But again, Your Honor...
So it's not analogous to a constitutional case in the sense that you look to the nature of the offense as against the violation here. You're looking at a federal statute, and if the federal statute says that you suppress it because of a technicality, then we have no authority to admit it on the ground that it is a technicality.
Except that it's federal law that controls here, and it's federal law that determines the admissibility of the evidence. And unless you make a very broad reading of the federal wiretap statute itself, you'll find that it simply does not incorporate state law beyond the initial authorization process. And to the extent that it does, and even under the broadest interpretation that any federal court has ever rendered, that is the interpretation given by the Second Circuit in United States versus Sotomayor, upon which defendant relies heavily, even under that interpretation, because of the nature of the violations that occurred in this case, the evidence simply can't be suppressed by this court. And for these reasons, we urge the court to affirm the lower court's ruling that the wiretap evidence was properly admitted. Thank you.
Thank you. We'll hear from co-counsel.
Mr. Chief Justice, and may it please the court, I'll be addressing the issue of whether the Klingon organization's membership list can be constitutionally compelled. There are three main points that I want to make, focusing mainly on the first, that there has been no infringement of defendants' associational rights. And second, that even if there were, that infringement would be acceptable because of the compelling state interest that exists in this case. And finally, that the compelled disclosure of the Klingon organization's membership list was substantially connected to that interest and narrowly tailored to protect associational rights. First, there has been no infringement of defendants' associational rights. The compelled disclosure of an organization's membership list can only potentially be, and through an indirect way, infringe on associational rights.
Well, we've got square holdings, as many as I can list, that says that clearly is a violation of, or implicates associational rights. Do you want us to abandon those cases?
It is true that there are many rulings that say that the disclosure of a membership list does implicate associational rights, but it is not the disclosure itself that violates freedom of association. This court in NAACV versus Alabama articulated a rule whereby the defendant, or whoever it is that's alleging an infringement of associational rights, must come forward and show certain things for the disclosure of a membership list to arise to that level. Now, the counsel for defendant has asserted that in NAACP versus Alabama, this court held that it was an automatic infringement, but that is not so. The court held that disclosure, quote, may constitute, close quote, such an infringement. And it found that it would constitute such in the NAACP's case because the disclosure of this list to the public would constitute a substantial restraint on the ability of the members of the Klingon organization to continue to associate because of resulting public hostilities that would occur because certain members of the organization's names would appear on the list. The court found that it was only under those circumstances that an infringement was found and that it would go on to further constitutional analysis.
You don't think that exists here?
No, Your Honor. What the court required was two things: public disclosure and public hostilities. Or if there wasn't public disclosure, that if there would be those public hostilities. This is the harm that must result, that infringes somewhat on the ability of the members of the group to continue to associate. Here, there was no public disclosure of this list, nor there will be. The protective order issued by the district judge prevented the disclosure of the list.
What about this 30-day gap that we've heard about?
There is no evidence that the list was disclosed to the public during that time.
Well, I guess our concern is not that it may not have occurred or the record may not reflect that it occurred, but the potential for it occurring is exactly what they were concerned about in NAACP versus Alabama.
So then if the court is concerned with the potential of there being public disclosure, then it should go on to the second step, that if that did occur, would there be resulting public hostilities that would prevent the members of the group from continuing to associate? And once again, there is no evidence that public disclosure of this list would result in that. This court has placed that burden on the defendant to come forward and show an infringement. If that is shown, then the government must prove the further constitutional burdens. If the defendant, however, were to prove those two requirements, the infringement would still be acceptable because of the very strong, compelling state interest that exists in this case. An examination of certain facts reveals how compelling of an interest was at stake here. As was mentioned earlier, there's two bombings that were in the minds of the investigators, the one for which the defendant was implicated and the one that had occurred earlier. That bombing, the first bombing, resulted in the death of 2 individuals and injured 25 others.
Well, counsel, we're familiar with all those facts.
Okay.
Why didn't you just ask the executive director or president whether or not the defendant's name was on his list? He offered that to you, didn't he?
There's 2 reasons why. Defendant has stated, or counsel for defendant has stated, that they knew the name of the defendant before they received the membership list. That is not true. On the record on page 1-15, it shows that they did not have the name of the defendant until after the membership was disclosed, the membership list was disclosed.
Did they have the means by which to identify him, whether or not they had his name per se?
They did not, Your Honor. They had no idea who the defendant was at the time. The investigation that was being done by the state investigators had not been turned over yet to the federal investigators at that time.
Well, so this was just a fishing expedition to see who you might target?
Essentially, in a way, it could be characterized as that, Your Honor. But because of all of the clear proof that tied the Klingon organization to the second bombing, it was more than that. It was a justified search for whoever was responsible for the bombing.
What was the proof that tied the organization to the bombing as distinguished from its members?
All right, there were several things that tied the organization to the bombing. The first bombing came a few days after the United States imposed a trade embargo against the country of Cardassia. That's the country with whom the Klingon organization affiliates. The second bombing also came a few days after the U.S. cut off diplomatic relations with Cardassia. We have the statement by Gul Dukat, the leader of the Klingon organization, that in response to the diplomatic cutoff, that a violent response could be forthcoming.
Would any of that support probable cause
There's
to go
more-
in with a warrant?
There's actually more than that, Your Honor. The event that tied the organization, the Klingon organization, to the second bombing more than any other was that the second bombing was of the bomb used in the second bombing was of the same type and model as the bomb used in the first. All of these events, or all of these facts looked at exclusively in their own little department, would suggest, well, no, there's not enough to tie this to the Klingon organization.
Well, let me interrupt you for a moment and go back to a question the Chief Justice asked you. You don't really mean tying the organization to the bombing. We're talking here about tying members of the organization to the bombing. By coming forth and saying we're tying the organization to the bombing, maybe you're giving us pretty good reasons to not want to have lists published.
Well, what this court in the past has held in NAACP versus Claiborne Hardware and Bryant v. Zimmerman, that if an organization or its members intend to accomplish its goals through violent means, then the rights of association in that group are not protected. The ultimate value of any society is self-preservation, as held in Uphouse versus Wyman, and it outweighs any value one may have in freedom of association.
In the NAACP case, that was a civil case, am I correct?
Yes, that is correct,
What kind
Your
of
Honor.
case were we dealing about in which was the communist?
There's a couple of cases.
Yeah,
Communist
the
Party
Communist
versus
Party
Subversive
case.
Activities
Any of those
Control Board.
involve criminal prosecutions?
I believe that those were also civil cases where the Communist Party challenged the statute which required the disclosure of the Communist Party members' list.
Neither of those cases involved this situation where the list was being used merely as a means of trying to identify possible suspects in a criminal case.
Those cases,
you
no,
know.
but there are many other cases where this court and circuit courts have allowed a membership list to be disclosed in a criminal investigation. For example, in United States versus Apker, an Eighth Circuit decision which was decided in 1983, that case involved a Hells Angel membership list. And there the court held that there was a compelling interest to have the list, and in addition,
That was because of a history of violence, though, and that's what you don't have here.
well, it's the government's position that there is a history of violence. There's
If-
two
and If we
bombings.
disagree with that, then Aker doesn't help you, does it?
That's correct, yes.
Let me ask you this, because frankly, I have forgotten. There was a confidential informant who provided an affidavit and indicated the delivery of some barrels and 4 devices. When in terms of time did that occur?
That occurred before the membership list was disclosed, but it was to the state investigators that information pertained. And so the federal investigators did not have it until after the membership list was disclosed.
And that would not be helpful in identifying this organization.
That's correct. The leader of the Klingon organization did offer to give the federal investigators information about members if the investigators came forward with names. But at the time that the investigators were asking for the list, they did not have any names to go by. In addition to having such a compelling state interest in this case, the state interest was substantially connected to the disclosure of the membership list and narrowly tailored to protect associational rights. Because the list was essential to the state's investigation of defendant, it was substantially connected to that interest. Furthermore, because of the protective order which prevented public disclosure of this list, and because the investigators had no other option available to them to get this information about the Klingon organization, the disclosure of the list was narrowly tailored to minimize any infringement on associational rights. Now, I want to go back to a point that Your Honors made regarding standing. This is an important point. If the investigators were going to get that information without the membership list, then there would be no harm. And it's important that we look at the cases that have...
Is that some kind of inevitable discovery doctrine that's brought into the First Amendment context? I don't know that there's any such thing, is there?
No, it's not an inevitable discovery. I don't think so. It could be somewhat analogized to that.
The fact is that once the list is turned over, there is injury at that juncture. And if it's cognizable, and it's cognizable irrespective of whether it would have come forward in any event, isn't there?
Well, it's the government's position that there is not injury as soon as the list is
Well,
turned
but your
over.
hypothetical assumed injury and said that it wouldn't be cognizable.
Well, if they're going to get the information anyway, my point now is that there is no standing because there is no injury. There's no injury to begin with because the defendant has not shown that a public disclosure would result in hostilities against him. But what this court held in NAACP versus Alabama and other cases where a group represented the organization, then it was able to look at the infringement on the members of the group. But where only an individual is coming forward and saying that the membership list infringes on associational rights, and the court can only look to the rights of that individual. Therefore, if there's no injury against the defendant, there is no injury at all, and there's no need for this court to go into the further constitutional analysis.
I think I may have misunderstood. Did you indicate that if they were going to get the information anyway, and if they're going to get the information anyway, if I understand, doesn't that invite us to suggest if there were other means, that they should use those means rather than this intrusive process of imposing upon the obtaining of the list?
Yeah, I see your point, Your Honor. I only argue that in the alternative, that if there was an infringement here, then once again, there would still be no harm because there's no harm to the defendant.
I don't know if the alternative argument or characterization post hoc saves you. Once you've admitted, as my colleague says, that there was another alternative, why weren't you required to avail yourself of it?
I'm not saying that there is another alternative. I'm just saying that if the court were to find that there was another alternative.
I thought you said that the list or the identification would have become available anyway.
I was saying if it were to become available anyway, there would be no infringement of defendant's associational rights because there's no harm to him at all here because there's no public hostilities nor public disclosure of the list.
Now, when you say if, you're presupposing that you would get honest responses from these people, and that would be a dangerous thing to do in this circumstance.
Well, one of the reasons why the investigators could not go to Gul Dukat to find out information about the Klingon organization was that he had made statements which suggested that the Klingon organization would violently respond to U.S. policy decisions. Obviously, in the investigator's mind, he would not be a credible witness. So that option to go to him and get information was not available to the investigators.
Or at least it wasn't viable at all.
That's right, it wasn't viable at all. Finally, one final point on the narrowly tailored test. Every case that this court has decided regarding membership list issues, this court has not applied the narrowly tailored test. Now, usually that's because the court hasn't found a compelling state interest. But in Communist Party versus Subversive Activities Control Board and Uphouse versus Wyman, where this court found the infringement to be acceptable, they did not apply the narrowly tailored test. In the lower circuit courts where they are continuing to apply the rules established by this court regarding membership lists, they are not applying the narrowly tailored test. For some reason in this context,
it had been torn off from about this level in the arm. All of the muscle on the top of the arm was exposed. The nerves weren't severed. So there was a chance that some of her function would come back. But at the same time, there was a good chance that even if I could reestablish blood flow into her arm, that it may still not work, and that she still may lose the arm.
Over the next 2 months, Holly underwent a series of operations to try to repair her damaged right arm.
She made remarkable progress in the hospital. I believe it was a week after her first 2 surgeries.
rights, and because of the compelling state interest that exists in this case, The Klingon organization's membership list can be constitutionally compelled, and this court should uphold the lower court's decisions. Thank you.
Thank you. The court will now adjourn and deliberate and return. Oh, you have rebuttal time. Oh, the bailiff failed to tell me that you had rebuttal time. You'll be appropriately sanctioned. Go ahead.
We need this time. 2 points, Your Honors. With respect to the wiretapping issue, respondent bases his argument on the fact or on the idea that this wiretap was gathered unlawfully and that minimization of the wiretap did occur. While it is true that we have not alleged that privacy was unduly violated and that minimization did not occur, we're treading on dangerous waters here because there is no support in the record for any conclusion. In other words, we don't have the wiretapping evidence. We don't have the minimization reports. And so the presumption in this case should be that minimization did not occur and that privacy rights were violated. The point that we have before the court is we do not know whether minimization did not occur or whether privacy was violated.
You're the movement in the court below on the motion to suppress. Isn't it your obligation to make sure that the record is complete for the purposes of that court and for purposes of appeal?
Well, for purposes of this hearing, we received the record and had no say in what was in the record or how it was compiled.
We do know one other thing. We know that the evidence that was introduced, the wiretap evidence that introduced, was relevant and would not have been excluded under any minimization. We do know that.
That's right. We do know it was relevant, but we do not know to what extent minimization did or did not occur. And therefore, to simply assume that it was lawful just because they had a piece of paper that had a wiretapping order on it or that privacy was not violated is going to be incorrect.
So it really is, as the government says, just a technical violation of no great moment, isn't it?
Well, we do not know. These laws that were violated were designed to protect the privacy rights of the individuals. We do not know if privacy was violated, but we cannot conclude that it was or it was not. And based upon the fact that the laws that were violated were based upon privacy rights, it should be suppressed.
But unless we go the route of Sotomayor, then all of this is irrelevant in any event, isn't it?
No, it's really not, because the laws that need to be given respect, the state laws that need respect, are ones that are based upon protecting privacy rights. And
Well,
those are
right,
the
but
laws.
we don't look beyond the state requirement. The state requirement says that there must be the minimization review. If there wasn't, and state law is incorporated, then you win.
That's right.
And if not, then you lose whether or not privacy was violated,
That's
right?
right.
So it's irrelevant.
Now, one last point. As far as when the government had the name of petitioner, we need to look to the record to know that on November 17th, on page 1-14 of the record, upon termination of the wiretapping evidence was turned over to the government. December 5th, a deposition of Gall Ducat was taken. December 20th, on the record in page 120 and 121, the membership list was actually turned over. Therefore, before the deposition of Gall Ducat, they had the name of Galler-Honduras. They could have asked Gall Ducat on November 17th if he was a member of the Klingon organization. Thank you very much.
That's the date when the material was turned over from the state to the
That's
feds?
exactly right, November 17th. Thank you, Your Honors.
Thank you. Do you have rebuttal time? Okay. We will now adjourn, deliberate, and return in a moment. Thank you.
The judges will probably take about 15 minutes to decide. Go ahead, get a drink, do whatever you'd like. Come back in about 15 minutes for the presentation of the awards. And again, the judges will remain for any questions that you would like to ask them regarding anything. So, thank you.
All right.
Be seated, please. The court has now reached its judgments in the case before us. To be honest with you, because of the difficulty of the issue, we considered saying that we had improvidently granted certiorari in the case. Because of the quality of the arguments, we considered just dividing 2-2 and just saying nothing. But under the court's rule of necessity, we don't have that option, so we must decide everything that comes before us, which we will do. In that light, after careful consideration and recognizing that there's a certain serendipity in any decision like this, the court has concluded that the best oral argument will go to Mr. Lee on behalf of the respondents. Best oralist, Mr. Lee. Congratulations. The same difficulties beset us in determining the best brief, but after reflection, we decided that the best brief should go to the respondents as well. So. That leaves the final category in which we were asked to render judgment, and that's as to the best team. That is a judgment that calls upon us to weigh both the brief as well as the arguments that were made by both individuals on behalf of each team. And as to that, we concluded that the best team is the petitioners. That did leave the fourth category, as to which we didn't have as much difficulty as we did in the first three. That's the runner-up team, and that's the respondents. So. The court now, in conference with the Moot Court Board, has agreed to render advisory opinions on just about anything that comes to your mind for as long as you'd like to ask questions, up to dinner time. We hope it's much shorter than that. Let me just say on behalf of the court, and then my colleagues can say whatever they'd like. I think all of us would agree that that the problem that you were confronted with is essentially intractable. I came in from Washington on a 4-hour flight last night, at which point I was looking at this. If I had gone on to Honolulu, I couldn't have figured this case out. and I haven't figured it out yet, and I just hope to goodness that my court never hears this case. In my limited experience, it's one of the most difficult moot court problems analytically that I've encountered. But I thought, and I think that my colleagues concur, that both the briefing and the oral arguments were superb and were virtually indistinguishable. And you don't know me, but I wouldn't necessarily say that if I didn't believe it. I thought it was that's true, and that's a real credit to all of you. So with that, I'll turn it over to my colleagues with any comments they'd like to make.
There's an old trial warhorse in Salt Lake by the name of Glenn Haney. And one of the things as a trial judge, when he used to appear in front of me, that always got my attention, and was equal amongst all of you, when you walked up the podium without a note in hand, prepared to go. You've had months to prepare for this, or at least weeks. You're not going to have that type of time or those types of luxuries when you get out and practice. But if you have the ability and time, and you don't have to bill your client for it, to be able to be as prepared in everything you ever present in court as you were today, all of us will be better served.
Let me just make a simple observation. In district court in our community, we do a lot of naturalizations. And all of us like to do naturalizations because that's a circumstance when no one loses. And I think really what we saw today was in the same category. There really have been no losers today. This school has produced remarkable students, remarkable lawyers. We have a good many in our community. And these representatives of yours have done you proud. We were very pleased to be permitted to participate in this process.
Well, I'll just add a few words and agree with my colleagues on everything. It was a superb performance today. The oral arguments were just outstanding. I thought you stood up well to the questioning. It was a very difficult problem, I thought, and that's not just coming from me. Maybe a lot of problems are difficult to me, but my law clerks even recognized that it was a difficult problem. And you handled it quite well, very well. And I congratulate you. It was, you were dealing with bad legislation at the federal level and bad legislation at the state level, and it complicated it. And you did a good job, an outstanding job.
Chief Justice, if I may make a single observation. I noticed a tactic that I think I've never seen before, and I'm going to assume that it was intentional. In all the writing, the grammar was outstanding, and there were no typographical errors, except in one place in each brief, and they were very obvious places. Now, I'm going to assume, because they were obvious enough, that you did that intentionally to make sure that the judges read your briefs and identified those obvious mistakes.
With that, we'll just open it up to questions on either the problem, as long as the questions aren't too difficult, and otherwise on anything about the profession or judging or life. Just open it up.
This is your chance to ask judges questions. The rest of your professional life, you will never be able to do this.
With all due respect to the court, did you feel bad about being so mean to the students?
Let me take that one on. The answer is, if I thought I had been, I wouldn't feel sorry in the slightest. But more importantly, I don't think we were. I don't think you heard a question today that would not have been asked. I know so in my court. In fact, my court, from the moment you step to the podium to the time you sit down, you're answering questions. And so I try to conduct moot courts exactly the way I do, court myself. So, but no, I wouldn't feel sorry in any event. I mean, this is a competition and it's fun. And but I think you got a realistic impression of what it would be like to stand before any of our courts, and it would probably be much worse in the sense you're talking about before the United States Supreme Court, as Solicitor General Lee there could tell you in a minute. So.
I'm kind of new at this. I've only been doing this a few months. I was a trial judge for 9 years, and so my experience is probably more like Judge George's. But I remember when I was a trial judge, is that my idea was I was trying to engage the person on the other side of the podium to help me. And it was truly an engagement, not in the sense of a battle, but I was trying to engage this person. And a lot of times there was hostility. Is that this how, this person is asking me questions. Let me get on with my presentation. And I think that's something that everyone needs to overcome. The engagement, I thought, helped me very much as a trial judge, and it has helped me to a lesser degree, but it has helped me a lot as an appellate judge.
I enjoyed it, inflicting I served a tour of duty, as we called it, in a prior incarnation as an appellate counsel, and I got a lot of injuries inflicted on me, and it's get even time. I've been doing that on the Court of Veterans' Appeals, and I was pleased to continue today.
You develop a kind of callousness, I guess, is what's being said, but very sincerely, I hope that everyone had the feeling that judges search. They really want to do the right thing. And the inquiries are made with the hope that the responses will be useful and helpful. And I agree with our Chief Justice that this was, I think, a good example. As a matter of fact, I thought maybe not as difficult as some courts might have been, but I think it was very close. And the purpose really, and I hope we always believe, that this process is a search for truth and for the best result. And we look to counsel to help us. And it's so important that the legal profession is producing people like yourselves who I think make it a worthy profession.
Yes, ma'am.
Did you start out your legal profession with the hope or intent of being judges, or did it just kind of turn out that way? And if people here would like to be judges, can you offer any kind of guidance?
I was going to be a banker. And then sometimes I wonder what I made some poor choices. I think what happens sometimes is that you're doing something. I remember I was trying right in the middle of a 10-week antitrust trial in front of a jury, and we were in on a Saturday morning working with Judge Alden Anderson up in Salt Lake, and I looked over and I thought, this guy doesn't have a bad job. And so I started thinking about it early, but just from observation. But the opportunities are few. The setting is serendipitous. So don't plan your life around it. But if it comes and you're interested, go for it.
I really discovered early, I think, that I liked the thought of being a judge. One of the great benefits and luxuries is being in a position where you simply ask the question, what's the best result and what's right? you don't always have that opportunity as a lawyer. I practiced law for about 13 years and did enjoy it. But I took advantage of opportunities. I served in a number of judicial capacities and confirmed the fact that I enjoyed doing that, and I would suggest that some of you who may be interested may take an opportunity to be, they call in judges occasionally to sit in one court or another and to do juvenile work, and you get an impression, I think, and I like the idea of it, and not many years into my practice decided that I wouldn't mind doing this full time. Notwithstanding, it's what many call dignified poverty.
Other questions? Yes, sir.
I know that most of you probably hear criminal issues more than civil, but which do you prefer? Would you have a preference? And is there, on the career track to becoming a judge, is it better to go the criminal route or the civil route, or does it matter?
Well, I'm a peculiar sort of judge. I'm on the Court of Veterans Appeals, so we only hear that one kind of case. On the other hand, I was the chief judge of the Army Court of Review, which was a criminal court entirely, so I've had both of it, but I've never been on a court where I had a mix of civil and criminal. The one court I was on was entirely criminal. Well, I better rephrase that. It was a court that dealt entirely with criminal matters, and the court I'm on now deals entirely with a very specialized kind of civil case. I think, frankly, I would prefer to be on a kind of court where you got a mix of that. I think that would be appealing to me. And maybe that's the grass is always greener kind of thing, I don't know.
I enjoy both, and I'm glad that I do have the mix. In terms of what would provide the best training, this is a simple answer to a question that has many more ramifications than I can deal with. But I've come to the conclusion that a good trial lawyer is a good trial lawyer. And a person who does well in a criminal trial setting, being familiar with and comfortable with the courtroom setting, I think you get the training, the more of it you do, I think the better. But I wouldn't be too troubled with starting out at least and doing some criminal work, and I think the transition is really easier. The most important thing is establishing a level of comfort in the courtroom and dealing with the judge and preparing and making discoveries. For example, when I was a trial lawyer, at least for me, I found that it was far better not to write down questions, but to write down answers. And when I was able to get the answer that I wanted, then I would move on, because in my judgment, the primary purpose, at least in the trial court, is to get answers from which you can make arguments. And it helped me because I could, it appeared, I think, that it was much more impromptu and spontaneous, and but that would apply to either criminal or civil. I'm 66, and I'll take senior status in about a year, and I intend to try both civil and criminal cases. I'm not going to try any 1983 cases, however.
Questions? Yes, sir.
For those of us who are aspiring litigators, what would you say are the qualities that we should aspire to, other than assuming preparation? And what are the things that we should do to avoid taking off a judge? What should we avoid?
Well, I think I was a litigator in private practice, and I think that litigation is as it is at the heart of the adversarial system. It's a competitive enterprise. That's the whole premise of the adversarial system, is that one side does its best and the other side does its best, and through the two performances, the court can divine the answer. So I think if you don't like the competition, whether it be with yourself or with others, then I'm not sure litigation is the first thing I would recommend to you. The second thing I think that came to mind for me about being a litigator is that litigators, one, have to be extremely well organized, but oddly enough, they have to be able to respond to the chaos and disorganization that surrounds them all the time. The litigator's life is wholly unpredictable, unlike, for instance, a corporate attorney or a tax attorney. Everyone's subject to call occasionally, but a litigator's always on call because it is at the beck and call of the court and of the other parties and of the discovery process and whatever it might be. If you don't like those two things and you don't like incredibly long hours of work, then you're probably not cut out to be a litigator. On the other hand, if you like all of that, and particularly if you like writing and if you like the case law itself, then those are probably the what I would call the fundamentals for litigating. That and a sense of humor, as is true with anything. I had a friend, you're always filing things with the court, and it's always under this incredible deadline, and you never have it ready in time. I had a friend who was filing a brief in the Supreme Court of the United States, and it had to be in by 5 o'clock in the afternoon, and he had all of his paralegals and his administrative staff there, and they dotted the I's and crossed the T's, and he said, okay, now go file this in the Supreme Court of the United States. Is that clear? He said, absolutely. And off the messenger went. And my friend was sitting there about an hour later, and the messenger came back, and my friend said, did you file it in the right place? Did you get it there on time? He says, absolutely, sir, absolutely. And he said, well, you get a receipt at the Supreme Court for the filing. Do you have the receipt? This is the most important matter that our firm's handled in months. Absolutely, sir. Here's the receipt. I brought it back to you. My friend looks down, and it said, his date and time stamped, Superior Court of the District of Columbia. And the messenger had filed the brief in Superior Court instead of the Supreme Court. I mean, that's the kind of thing that goes on in litigation, it seems like, all the time. You're always right up against a deadline. If you're not comfortable living on the edge like that, you're probably not going to be at least a healthy litigator. So.
Let me add one comment to Mr. Zimmerman's inquiry. You talk about not ticking off the judge, and along with preparedness, and judges always expect and appreciate preparedness because they are looking for help and they are looking for guidance. But common courtesies, I can't overemphasize how important it is to be respectful, not only to the judge, but to other counsel. Nothing offends or disturbs, particularly a trial judge, more than having counsel argue with one another. It's one of the most foolish things that you can do, and many new lawyers have that tendency to stand up in the midst of an argument and argue with counsel. It's silly, because you don't need to convince opposing counsel, you need to convince the court. And the court gets an uneasy feeling that the judge is losing control, and never engage in that, and any good trial judge will not permit it. And I would suggest to you to never let that happen. Sense of humor is really important, and a story that you may enjoy. A friend had worked for the district attorney's office, and as so often is the case, they would just hand them a brief, especially if it was a loser, and hand it to the youngest lawyer, and he went before the Supreme Court, and a kindly Supreme Court justice said, Mr. Morris, I think we've confused you. And Mr. Morris responded, with all due respect, Your Honor, I was confused when I came here.
questions. Sure.
I was at Mr. Murphy's confirmation hearing this summer, and the Senate seemed to like him very much. I know you've all been through confirmation. The Federalist Society just had a seminar about proposed constitutional amendments, where the Congress is not attempting to change the Constitution as much as correct the court. I'm wondering if you could comment on your relationship with the legislative branch in terms of lawmaking authority and your effect versus their effect on society. And I guess I'm asking, to some extent, who's in charge to resolve the problems in our lives?
There's a clear problem between the branches of government, obviously. I've written a paper, and I wrote a paper about the administrative structure of the courts. It's very simply written. Come up and see me afterwards. I'll send you a copy. I wrote it because of some visits abroad, and I think our administrative structure works very well. There is a body that I think appropriately speaks for the court, and it's the United States Judicial Conference, and I think they do a remarkable job. The Chief Justice always presides over that body, and I think it not inappropriate that from time to time the judiciary comment about, in a limited fashion, about legislation, about its impact on the court. We've even addressed questions of salary and so forth, and I think it's important that the judges recognize that there is that body. Right now, there's kind of an interesting thing going on. Senator Grassley, who's a fine senator, has sent a questionnaire to every Article III judge in the country. I think that troubles most Article III judges, that there's that kind of mix. But we're provided an opportunity. All of us here probably have testified before committees, congressional committees, and they're quite willing and quite considerate. We deal with our own congressional representatives and talk to them and respond to them and address issues. But I think there's some caution that needs to be exercised and be sure that we don't violate the fundamental principles established by the Constitution. There also in each circuit is a judicial council that serves that function and does it very well, disciplines judges and so forth. It's a very effective organization for the administration of the federal judiciary, at least in my judgment.
You did touch upon one of the most hotly contested issues in the past 10 or 15 years with respect to the role of the judiciary when you asked who's responsible for dealing with the problems of society. There are several schools of thought, but at either extreme, there's a school that says the judges have no role at all to play in resolving societal problems, except to the extent that they interpret the law as the policymakers have written the law. There's another school on the other end of that spectrum that says that the judiciary should play a major role in resolving problems through its own policy-making function. That we're not going to resolve that debate today, but that is a question of jurisprudence and philosophy of judging. I have said repeatedly that in my judgment that society should not want the judiciary attempting to solve society's problems for one simple reason. I guess two, actually. One, under the structure of government that all of us gave each other, that's not how our role's been defined. And secondly, and equally important, you've got to keep in mind that we are appointed for life. You don't think about that much in law school. What that means is that in the only ways that matter in a free society, we are not accountable to anyone. I can take this problem today and put the statute aside and ask myself, what do I think would be the just thing? What would be best in our society to do? And I have no problem. I can decide. I have opinions, and I can say this would be best. Well, the problem with that is that who am I to say what's best? And if you happen to disagree with what I think is best, that's tough luck, because when I put it down, it's law, and you're bound by it. So what you should want, and what we should want as a people, are for these problems and issues to be resolved by representatives over whom we have some control. That's what I've never understood. It seems so basic that you would want to be able to remove and hold accountable and remove an official who has control over your life. Because you may like my policies today, but you may not like my policies tomorrow. But if you give me the authority that I've talked about, you can't stop me tomorrow when I'm writing my policies into law. And that's something to think about.
It's nice to have questions like that in an atmosphere in a setting like this, rather than a politically charged setting. Those who take the view, the most restrictive view, as to what the judiciary should be doing, cannot possibly deny that it's the judiciary's obligation to answer questions such as those that were presented today. Once the judiciary answers a question such as those presented today, then those with the most restrictive approach say we have judicial activism, because we have resolved ambiguities, and that's what our job is. So it is going to occur. There are going to be things that happen even in the most restrictive view that can be alleged to be judicial activism, and I don't think that's a fair charge.
I agree with the observations made, and I take a fairly limited view of what we ought to be doing. But in my judgment, perhaps more important than that is looking at the totality of the structure, and you have an opportunity to visit other places. Something that I've absolutely concluded, that in a free society, you just simply have to be willing to tolerate a certain amount of abuse. But it's worth it, on balance. And I think, generally speaking, it works remarkably well. I'm troubled, as I'm confident some of you are, with some of the things that happen. But better to take a little abuse than so much that we see in many parts of the world.
Yes.
As judges, how do you feel about making members of the Supreme Court subject to term limitations as like appointments? That kind of goes along with this question.
There's a colleague of mine right now, Judge Robert Henry, who is on a trip to Belarus to assist them in the drafting of their constitution. And what he has observed is that they have a beautifully written constitution. It ought to work perfectly. The problem is that the personnel from the judiciary that he has spoken with, their comments to him indicate that they are deathly afraid of what would be the comparable to other branches of government. There is no independence of their judiciary, and as a result, chaos is still supreme. And his only view is that until they get to the point that they feel that they can take on the old Communist Party or the old bureaucrats who are still in office, until the judiciary feels that independence, nothing is going to work under their new constitutional system. And I think the inferences from what I've just said at least give you my response to your question.
Are you suggesting, you're not suggesting an election? You're suggesting simply limit the terms?
Just a term limit, yeah. It just seems to me that to put it to election would just make it like legislature. So I'm just wondering about the idea of, I'm not sure which side of the fence I myself fall on. I'm just curious what your perspective would be.
Well, a lot of courageous things have been done by judges because they're life tenured that I fear probably would not have happened. On the other side, probably a lot of very foolish and damaging things have been done. My own judgment in dealing with judges generally, and most of my association has been with federal judges, has been that they're remarkably well motivated and cautious. I replaced a dedicated Democrat. I was appointed by President Reagan. But the first thing he told me is, Lloyd, you have assumed one of the most powerful positions in government. The most important thing you can do is be cautious in the exercise of that power.
I guess I'm the only judge here that's got term limits. I'm on what they call an Article I court. There are 4 of them, I think, our court, the Court of Military Appeals, Claims Court, Tax Court, and they have missed one. Anyway, we're appointed for 15 years. I was appointed, I would think I was 56 when I got appointed. That's, to me, is a life, you know, that's as close as hey, I'm happy with that. That's, but that might be the compromise, a long-term appointment with an attractive retirement they might even agree with me. I don't know.
Well, I remember talking with a number of unsuccessful applicants for state judiciary positions. And one of the reasons most frequently given to me that they will not come back a second time is it was so incredibly destructive to their practice. Their partners were not happy with them. Clients felt that they were walking out the door on them. And when they were unsuccessful, here they were back, looking for more work and back with their partners. And I think you would have that same type of problem even under a term limit type situation. If you didn't, then you'd have a revolving door type situation. And I don't think you would want somebody going off the 10th Circuit, so to speak, because her term limit was up and go off and make 6 figures based on what they did before.
The problem that you have, in my judgment, doing what you suggest that has some attraction, perhaps, is it would require a constitutional amendment, of course. And I'm always troubled with messing with the Constitution. I'm fearful that if we started doing those things, the first thing that would go is the first 10 amendments. And so I would really have trouble with a constitutional amendment that would limit the terms of federal judges.
Yes, sir.
Is there not much room in an oral argument for kind of a common sense appeal or an appeal to the justice of your side of the case?
You mean if law is not on your side?
Only but if it is, how much do you respond to that?
I think that probably varies with the judge, but the answer is yes. Many times there is ambiguity in these statutes, and to the extent you have to interpret them, you're looking for something, some tool by which to do that. Common sense and reason is certainly a tool that you can resort to. What you got to avoid, and what is pretty much universally unacceptable, is to stand up and attempt to make arguments just based on common sense or policy or fairness or justice. I mean, you've got to at least try to come to grips with the law that's applicable before you can get past that threshold. But yeah, I mean, all the time, and even in appellate. Lloyd and I were talking, I mean, appellate courts and trial courts are just vastly different animals. I wouldn't even know where to start if I walked in a trial court. I couldn't even call the court to order, probably. You know, and in a trial court, you know, it seems to me that, at least from a distance, that those kind of arguments are, you know, are very, very important. Is that right, Lloyd?
Without any question. I think you're always looking to, does it make, I don't know how many of you were economics majors, but somebody was telling me the other day that two economists were talking and one said to the other, well, we know it works in practice, but the really important question is, will it work in theory? And sometimes we're plagued with that. We want to know if it'll work in practice.
I'm getting the sign from right back here. So I guess we're going to end, and I think we should thank the judges again for being here and participating.